Thank you very much indeed. I have come without PowerPoints. I'm flying free and also without Twitter right now because Rachel's taken us to Brussels. I'm taking us back to London and to the House of Commons where right now we have ongoing, day 7 we've reached of the committee stage of the Withdrawal Bill. Because, so what's happening right now? And if anybody knows, and if anybody
we'll shout
out everybody. Okay, so because that's the way it goes right now. So whatever agreement is reached in Brussels on the terms of the divorce and any new relationship that the UK may be able to forge with the European Union, there's some pretty significant housekeeping that's going to need to take place back here in the UK with our legal order to deal with the consequences of withdrawal, to deal with the legal and constitutional consequences. And as we said, right now, in Westminster, in the House of Commons, the government's withdrawal bill, the UK government's withdrawal bill, is being debated on the floor of the House as it progresses on its way to becoming law. It's now at the committee stage. And at this stage, the legislation has gone through line by line, and amendments and new clauses can be voted on. And it's this bill, which is the piece of legislation that will repeal the 1972 Act of Parliament, the European Communities Act, that took the UK into the European Union and which gives EU law its force within the UK. It's the route in for EU law for the UK and for Welsh law, for the way that it may be transposed locally. Now, the withdrawal bill is needed, according to the government, to bring about stability, continuity, and certainty to the withdrawal process, enabling a smooth transition out of EU membership. Because if we just cut off the European Communities Act and cut off that source of EU law, potentially we're left with a black hole we don't know the size of. If we no longer have that underpinning for a whole host of regulations and directives that we've inherited over the past 40 plus years of membership, then that leaves us with legal problems. So what the withdrawal bill seeks to do is repeal, its original name, the Great Repeal Bill, that it repeals that source, the European Communities Act, but it rolls forward most of our existing EU laws or EU-derived laws. And it also gives ministers powers to make changes to these laws where they're necessary in view of the withdrawal process and any new agreements that are reached. But this bill is, of course, proving hugely controversial. It's seen hundreds of amendments tabled, at least 400. Amendments which have led to close-run votes, which so far the government has won. Those that have been pushed to a vote, the government has been able to get a majority on its side. Now, tonight, though, that winning streak may come to an end. It may have come to an end. We may not be there yet. I don't know. Over amendments that are calling for the inclusion in the bill of provisions which give a meaningful vote to parliamentarians on the final deal. And that amendment, that new clause, is being tabled by the Conservative Dominic Grieve, who is the former Attorney General. Now, Grieve's interventions, and there are a number of amendments that he's tabled, but this one is the one that potentially is the one that's going to trip up the government. They reflect considerable concerns that many hold about the bill's impact on balance of power of the key institutions in our constitution. And it's seen to sort of shore up an ongoing shift from Parliament to government. And that's seen with the scope of these powers for ministers to take decisions, to change both secondary law but also acts of Parliament, to make those decisions without further need of parliamentary approval. And the bill also highlights a profound clash in understandings held by the UK government on the one hand, and the devolved governments on the other hand, about some fundamental principles in our UK constitution, such as the status of the devolution settlements and the devolved institutions, and also the continuing force of the principle of Westminster parliamentary sovereignty, which, not from a devolved perspective, but from a sort of a UK central government perspective, is seen as something all-powerful, against which the devolution settlements, which are themselves expressed in acts of parliament, are fundamentally vulnerable too. Now, if we look back over the past year or so in this process, what we do see is, of course, despite some very warm words at the start of the process about it being an inclusive process and we're having UK-wide agreement and approach, that what we see is in both the running of the external and also the internal dimensions of the withdrawal process, the devolved administrations have been essentially sidelined in this, and their voice has not been given the status that perhaps we could have been led to expect the devolved to have in this ongoing evolution of our constitution, that it doesn't reflect and respect that 20 years of the devolution, the creation of new representative institutions, the devolution of powers that have been endorsed and supported by referenda, democratic votes within the devolved nations. And the devolved institutions and administrations are essentially seen as another group of stakeholders. It's very dramatic, isn't it? What have I said? I'm thinking Boris. I think
taking over.
So the bill has been described, we know, as a power grab, which sees rather than powers and policy responsibilities in areas such as agriculture and in the environment flowing back to the devolveds following the devolution settlements, following the Government of Wales Act and the Scotland Act that say that these are areas of devolved policy responsibility. Yes, they're currently shared and exercised with others in Brussels, but according to that devolution legislation, they are devolved powers. That the bill effectively sees these powers and control returned to Whitehall and to Westminster. Because under the bill's clause 11, significant restrictions are placed on the Welsh Assembly's and the Scottish Parliament's powers to adopt laws in these areas returning from Brussels. The UK government says that these restrictions are only temporary. And they're only temporary and they're only there whilst it's working out where new UK-wide rules are needed. And it says that we're going to need UK-wide rules to make sure that differences don't emerge in the way that the different parts of the UK deal with certain issues that might then disrupt the flow of trade, both internally by having different regulations on environmental measures, on product requirements. So it doesn't have an impact internally, and also that it doesn't have an impact on our ability to make international trade deals where you're committing for the whole of the UK. Now that's fair enough, and both the Scottish Parliament and the Welsh governments accept that and say we see that common approaches are necessary. But where there's disagreement and where there's a weight of academic opinion and also sort of my own contributions in this field to say, you know, the way that Clause 11 sets about doing this is a very sort of heavy-handed, very centralising approach, and there are other ways that we could affect that necessary coordination. So, we've also been looking in the WGC about this emerging idea of a UK internal market and trying to get a handle on what that might look like and how it might work, and also caution it being presented as a sort of a wholly economic concept, because we risk then losing some very valuable protections for certain values and concerns and interests when we're thinking about the market and how it operates. Also, from a devolved perspective, there are concerns about the opportunities for effective engagement in the process of deciding when and where UK rules are required and what those rules might be. And there's a point of principle too about respecting those existing devolution settlements and not rolling back on those areas that have been devolved. So, during the Withdrawal Bill's committee stage, amendments calling for the removal of Clause 11 were tabled for the Welsh and Scottish governments by sympathetic MPs, and these were defeated. The government also won on a vote yesterday on amendments to clauses which effectively give powers to UK ministers to change the devolution settlements without Acts of Parliament or the devolved administrations giving any sort of consent. So the UK government is reaching the end of the committee stage, bruised but so far undefeated. After the committee stage, when we'll have 1 day left, we've had tabled 8 days in the Commons to go through this process of working through the amendments. After this, in the new year, the legislation will pass to the House of Lords. And we expect there that the reception will be very much bumpier. But the Lords can't block the legislation. It can delay it, but it cannot block it. Also to add in, looking forward next year, there's also a role for the devolved parliaments and the assemblies, and they'll be asked to give their legislative consent. You know, the Sewell Convention, the constitutional convention that the UK Parliament, Westminster, will not legislate on devolved areas or on matters to do with the scope of devolved powers without the consent of the devolved parliaments. And the UK government has accepted that the Withdrawal Bill engages the Sewell Convention. And it said we will come to the parliaments and the assemblies and we will seek that consent. So they've said that. What we have is, at the moment, a clear statement from the Scottish government and the Welsh government that they are simply unable, as things stand, to recommend that their parliaments and assemblies give such consent. That the degree of dissatisfaction with those clauses in the Withdrawal Bill, absolute red lines that they're maintaining still, will lead them to reject any legislative consent memorandum. Now, whilst these things are making their way through Parliament, the governments have been holding meetings, the UK governments, so the devolved ministers, and David Davis and Damien Green have been holding meetings after a sort of period where the JMC, these opportunities, these frameworks for ministers to meet together. There's a JMC around European negotiations that was sort of set up with quite a lot of optimism and positivity from some and a certain sort of jaded resignation from others. And it sort of fell into abeyance quite quickly. And then had a bit of a kick, and back in October it met, and it seemed to be making a breakthrough. And there was agreement then about the principles that would underpin the creation of these common frameworks, where we would need to continue to have UK-wide rules. So those principles were set back at the JMC in October. We had another one of these ministerial meetings yesterday in London. And you usually get a communique afterwards. There's been not quite as much coming out of the one that we had yesterday. There's been a statement from, well, there was something from the Cabinet Office that puts quite a positive spin on the progress that is being made in deciding this. We've reached decision and we've got 3 categories: things which are going to need laws, things that need coordination but we can do it without law, and then things that we can just leave to the devolved to get on with on their own. So that's from the Cabinet Office. From the devolved side of things, that sort of positivity is missing. You know, they've come out of these meetings and they're taking us back to the Withdrawal Bill and they're taking us back to Clause 11, and they're saying that it doesn't matter what we're agreeing here right now. That's one thing. We need to go back to that piece of legislation and we need concrete agreement before it leaves the Commons that there will be changes made and there will be protections of the devolution legislation. Now, what we've now got is both the Welsh and the Scottish governments saying that if that is not brought forward, and if we don't get that, essentially before Christmas, then we will see the introduction of continuity legislation in Wales and in Scotland. And essentially, what this is the Welsh and the Scottish Parliament sticking a flag in the ground. And in those devolved areas, they are going to sort of occupy the field and turn existing EU law into law for Wales, into law for Scotland, and sort of state their purpose that this is ours. Okay. Now, ultimately, the way that our constitution is structured, of course, is that falling back on the principle of parliamentary sovereignty, the vulnerability of the devolution settlements. Ultimately, whilst it might be unconstitutional for the UK Parliament to do it, what it could do in the future is allow this continuity legislation to be adopted and then just introduce an Act of Parliament that would have effect across the UK. So it could be overturned and unpicked by a UK Act of Parliament, because that's the way our constitution is structured. And any such steps to any sort of self-protection by the devolved administrations could just be overturned. So that flexibility that our constitution has been so famous for, it's brought such advantages, also has some quite critical disadvantages as we move through the Brexit process. Okay.